Hello, everyone, and welcome. Welcome to another live edition of Employment Law Q&A. I am your host for today, Alex Lucifero. I'm an employment lawyer and managing partner of Samfiru Tumarkin's Ottawa office, coming to you live today from a very rainy, very gray Ottawa, Ontario. Here for the next half an hour, here to take any questions you have related to employment law, related to your workplace. If you're dealing with a difficult situation at work, if your boss is mistreating you, or if your employment terms are changing, maybe your boss is asking you to accept a different position or a different pay structure, or maybe you've been presented with a new employment contract at work. Really, any issues that you are having in your workplace, I don't care what they are. I am here to help advise you, to help guide you through that workplace problem. That is what we do as employment lawyers. We are here to resolve your workplace problems. So please, this is live right now. Feel free to ask your questions. Just type them in. You don't have to mention your employer's name. You don't have to get too personal or too confidential with respect to your information. Ask a generic question, even if you're not having a problem at work. Maybe you're curious about how much severance you're owed, or you're curious what your employer can and can't do in your employment. Go ahead and ask your question. Again, we've got half an hour right now to help you out. Couple of pieces of contact information right off the bat. If maybe you're a little bit too shy to ask your question on a live stream, or if you're seeing this after it's already been recorded, you can certainly contact us. Number one, at our website, employmentlawyer.ca is where you can find us. Employmentlawyer.ca. We've got a ton of resources on our website, articles, blog posts, news articles, you name it. You can find out about your situation there. It's also got all of our contact information. If you're looking for a particular lawyer, if you're looking for a particular office, we have offices across Canada, in Ottawa, Toronto, Vancouver, and Calgary. If you want to look for a lawyer in your region, again, go to our website. Another piece of contact information is our email address. We get tons of email all day, every day, at all hours of the day. Please email us. It's completely confidential, and I promise someone will get back to you. Our email address is help@employmentlawyer.ca. That's help@employmentlawyer.ca. Give us a brief description of your situation, and I promise someone will get back to you to help you out. Couple of topics I wanted to talk about today. And for those of you listening right now, again, if you want to ask questions about your employment situation, go ahead. Ask them right now. I promise I will get to them over the next half an hour. But as always, I do want to talk about a couple of matters that we are dealing with most recently in the employment law world. And I imagine this will help lots of you out there. The first big one is returning to work post-COVID, or returning to work given that restrictions have been relaxed, vaccination passports have been relaxed. Of course, we're still dealing with COVID, across society, but lots of employers nowadays are asking employees to return back to the office after potentially almost 2 years working from home. And lots of people are contacting us asking, can my employer actually ask me to return back to work? Do I have to say yes? Are there any health and safety issues I should be worried about? Is there anything I could use to my advantage to continue working from home? And generally speaking, the answer is as follows. I think if your employer is asking you back to work, and you have been working from home temporarily because of COVID, so I'm not talking about, if you always worked from home, right, and it's a permanent term of your contract, then you can continue working from home, right? If it's a permanent term of your contract, that is a right that you have. However, if you've been temporarily working from home because of COVID, and now your employer is asking you to return back to work, I hate to say it, but you probably have to return back to work as an employee. Because it was a temporary measure, and a temporary measure only, the employer is going to treat it as such and can then ask you to come back, because that was the implied or the permanent term of your employment. It was working at the office, or working at, at whatever site you were working at. So be very careful as an employee about refusing a return back to the office. There are only very limited circumstances in which you can actually refuse a return back to the physical office. One of which is potentially a medical disability or a safety or health and safety issue. So if your doctor is telling you specifically, maybe because you have some sort of medical condition, whatever the case may be, if your doctor is advising you not to return to the office, not to return to larger gatherings, then that is something you can actually use in your defense as an employee. So if you are an employee that deals with health issues, that perhaps has a weakened immune system, or there are concerns health and safety wise about going back to the office, speak to your doctor about it right away. If your doctor agrees with you and recommends that you should continue working from home as an accommodation, your employer does have to respect that accommodation. And so that might be one of the ways in which you can be allowed to continue working from home. However, that doesn't just come from you. You can't just plead with your employer to keep you working from home because you're worried about contracting COVID at work. It has to come from your doctor. It has to be a medical opinion. If you have any questions in that respect as an employee who's returning to the office and perhaps doesn't want to, or perhaps has some questions or concerns about it, go ahead and ask right now. Again, we've got until 12:30 Eastern time to deal with those questions, or alternatively, give us a call or send us an email. Again, our website is employmentlawyer.ca. Our email address is help@employmentlawyer.ca. For those of you just tuning in, once again, my name is Alex Lucifero. I am an employment lawyer. We resolve workplace problems all the time. I'm the managing partner of Samfiru Tumarkin LLP's Ottawa office. We are the employment lawyers. We're also the most positively reviewed employment law firm in the country, and so we must be doing something right. All right, guys, I see a couple of questions have come through already, which is excellent. That's what I love to see. Please keep asking your questions. Something I say actually quite often, and as a reminder, go ahead and post your question. Even if you're not sure about it, if you're a little shy about it, go ahead and post anyways. Not only are you going to be helping yourself, you're going to be helping others who have the exact same questions as you. We oftentimes, as employment lawyers, field the same 10 to 20 questions, all day, every day. So it's not just you that's dealing with this particular issue. It's not just you that has this particular question. There are dozens and dozens, if not hundreds and thousands of people out there dealing with the exact same problem, with the exact same issue. Go ahead and ask your question for yourself, of course, but also for all of those other people that are going to be watching and listening to this. You will be helping them as well in asking your question. So please go ahead. All right, first in line, Nancy, thank you for your question. She asks, how long does it take to get a resolution with the lawyer and employer? It's been 6 months. Nancy, the answer to your question, of course, depends. Some employers are very easy to deal with. And I would say that's the majority of employers out there. Some employers, however, are much more difficult to deal with, and it does take two to tango to a certain degree. When it comes to a straightforward severance negotiation, often those matters are quite simple. If the matter is more complicated, then obviously that is a difficulty, and that means that it might take a little bit longer to resolve. Sometimes some patience and some perseverance is required. That said, if you have a strong legal claim, then you should believe in the advice that you've been provided with, and stick it out. And eventually, I'm sure things will work out. Jordan asks, yesterday I was sent an email from an employer that had attached to it a provincial and federal tax form, as well as a skills update request. The employer already has my tax information. Is this a sign they're trying to turn it into an employment situation, negating old entitlements? Jordan, I need to know more specifically about what these tax forms are. I mean, it sounds like there is kind of an update to the terms of your employment. Listen, if they're just tax forms that are provided by, government bodies, whether it's provincial or federal, that's not going to change the terms of your employment, really. I mean, the only way I could see that changing potentially is if you are, perhaps a contractor and you're now being asked to sign documents, tax documents that consider you an employee. Perhaps that would be a change, of course. But otherwise, if you are already considered an employee of the company and you're simply signing updated tax forms, I don't see how your other terms of employment would change. In other words, if you're operating in a certain position, making a certain amount of money, and your hours are set, and your work responsibilities and your job function is set, I'm not sure how tax forms would have any impact on that. Now, this has to be kind of the most basic advice I could provide, Jordan, which is that if you have any kind of uncertainty about what you're signing or what you're agreeing to, you should not sign it, right? Get some advice, whether that's accounting advice because they're tax forms, or maybe if that's legal advice, so if those tax forms came with a more formal contract or more formal employment agreement or some sort of updated offer letter, well, that's a red flag. You need to speak to an employment lawyer about that, and certainly give us a call or send us an email or contact us any way you like with respect to the situation, which is actually something I wanted to talk about today, which is more and more nowadays, and for 2022, from the start of the year, we have been seeing employers roll out new employment agreements. Jordan, you might be in one of those situations. Be very, very cautious about signing updated or new employment contracts. The only thing that an employment contract will do is benefit the employer and limit what your rights and what your entitlements are as an employee. You should be receiving legal advice before signing an employment contract. Do not sign it on the spot. Do not sign it without speaking to one of our employment lawyers. A new employment contract is probably going to limit your severance. It's probably going to limit lots of other entitlements that you have with respect to maybe temporary layoffs. So a contract might allow the employer to temporarily lay you off, whereas without that contract, an employer is actually not allowed to lay you off. There's a host of things that an employment contract can do that will favor the employer and give the employer rights and take away rights from the employee. Be very cautious about signing updated employment contracts or updated employment agreements. They will only hurt, unfortunately, the employee. All right, Crystal is next in line. Crystal asks, if you were terminated due to a COVID vaccination policy and the employer refuses to settle in regards to severance, is it worth taking them to court to fight for severance when there's no case law that has been successful regarding COVID policies? In brackets, non-unionized, 10 years at this hospital, would the Bardolph factors apply? What an excellent question, Crystal. It's a question we have been dealing with lots over the past several months. Vaccination policies, termination rights, and severance rights when it comes to vaccination policies and employees being terminated. I can tell you this, with vaccine passports and with all of the mandates, and I'm talking specifically here in Ontario, but this is generally true across Canada as well, with all of those restrictions being lifted in the past few months, an employer's ability to argue cause or to argue that an employee is not owed any severance if they've been let go because of a vaccination policy, the employer's claims in that respect, their defense in that respect, has become weaker and weaker and weaker. It might have been weak to begin with, but they have become less and less viable as defenses. And so a very strict vaccination policies that says either be vaccinated or you are terminated without severance, in my opinion, it is unreasonable. That employee is going to be owed severance. Now, you're right to point out, Crystal, and as I was mentioning to Nancy previously, some employers are going to be difficult to deal with on this issue. Some employers have kind of doubled down on their vaccination policies, despite all of the restrictions being loosened. Employers have doubled down on this policy, and that makes for a difficult situation where maybe legal action is required. If you're a long service employee and your severance entitlements are significant, it may very well be worthwhile pursuing. It also depends on the particular circumstances of your case. You mentioned that you were working at a hospital. A hospital might take these kinds of claims more seriously, given the type of clientele, patients, of course, that they deal with. They might feel much more strongly about a vaccination policy, which makes the case more difficult. Ultimately, there was no government mandate in place with respect to hospitals, whether that was last year in 2021 or right now for that matter. And so I still think that it's going to be an uphill battle for an employer, even a hospital, to be able to establish cause for termination, meaning even employees let go from a hospital are owed severance. but that context needs to be taken into consideration. It also might matter, Crystal, how long it might take you to find a job or not. That's another relevant factor in assessing how much severance you might be owed. If you haven't spoken with one of our lawyers yet, you need to have a conversation with us and decide whether the benefits outweigh the potential difficulties in moving forward with legal action. Oftentimes, it does. Oftentimes, we can resolve these matters. Even once legal action starts, we can resolve these matters on successful terms. Have that conversation with your lawyer. You need to decide together whether it makes sense to pursue or not. And again, those are some of the factors that you need to take into consideration. Listen, as a 10-year employee, particularly if you are in a supervisor or management level position, again, your severance entitlements are probably significant. That's probably a good amount of money to pursue. It may very well be worthwhile. Thank you so much for the question. All right, moving on. Thank you all for the question. I promise I will get to all of them, so keep asking. I typically will do a rapid fire round in the kind of the last 5 minutes of the segment, but we've got plenty of time, so keep asking your questions. Next up, Christian asks, can I sue my employer for wrongful dismissal or discrimination after having 2 work-related injuries due to unsafe work conditions, and they didn't make any changes to my work area or job conditions after several requests and sitting down and sit down meeting with my employer? Another good question, Christian. I don't know how it's necessarily discrimination. I think you're using the wrong word there, unless there is something more to the claim. Keep in mind that discrimination means that you are being treated differently, or you're being punished in your employment, or if your employment is being terminated on the basis of a discriminatory ground. So, for example, if you feel like you are being mistreated in your situation because of your age or your religion or your gender or your nationality, that might be discrimination. Now, I don't see any of that in your comments, so perhaps discrimination is the wrong word. That said, this is a concern because if you are working in an unsafe work environment, yes, clearly that's a problem. You as an employee have the right to work in a healthy and safe work environment. That is a right of every employee in Ontario and every employee across Canada, for that matter. You should not have to work in unsafe conditions. Now, that said, Christian, I wouldn't necessarily just jump to wrongful dismissal in a situation like that. Here is the process when it comes to an unsafe work environment. And it sounds like you've already ticked the first box, which is you should speak to your employer about it. So if you've gone to your employer and you've expressed your concerns about the workplace safety, and they have gone unresponded to, unheeded, if your employer is not doing anything about it, you then have to move on to the next step in the process, which is contact the Ministry of Labor. That is the next step, particularly if you are in Ontario. This is how it works. You need to contact the Ministry of Labor. Someone from the Ministry of Labor will then come into the workplace and investigate and make a determination, right? Hopefully that resolves the issue right then and there. If the Ministry of Labor makes certain recommendations or certain suggestions and the employer then doesn't follow those, well, that's when you can potentially move to what's called a constructive dismissal. It's basically a wrongful dismissal. But before you make any kind of move in that respect, Christian, before you tell your employer you think you've been dismissed, or you mention constructive dismissal or mention wrongful dismissal, 2 things. Again, if you're still dealing with an unsafe work environment, contact the Ministry of Labor and they will get involved. Number 2, give us a call. Let's chat. Again, before you make any moves, before you speak to your employer at all about quitting or about dismissal, we need to strategize. We need to talk about what your options are and what your best option would be. Again, if you want to find our contact information, employmentlawyer.ca is where to reach us. If you want to email us, Christian, help@employmentlawyer.ca is where you can email us. Once again, guys, my name is Alex Lucifero. I'm an employment lawyer answering questions for the next 10 minutes with respect to any and all workplace situations. We, as employment lawyers, help people like you every single day when it comes to your workplace problems. If you've been let go from your job, if you're dealing with a temporary layoff, if you're dealing with a medical leave. And by the way, any questions about short-term or long-term disability leave or disability benefits, go ahead and throw them my way as well. Happy to answer any disability insurance related questions over the next 10 minutes as well. All right, next in line is Andy. Andy, thank you for your question. Let's have a look here. How frequently can my employer make changes to my duties before it would become a fundamental change to my position? Excellent question, Andy. How many changes, I guess, or how frequently can the employer make changes? I don't know if the frequency is an issue, Andy, if you know what I mean. So I don't know if changes need to be every so often. They need to be once a week or once every 2 weeks. So I don't think it's frequency that we're talking about here. I think it's degree of change. And I think you nailed it when you said it, needs to be a fundamental change. So, for example, maybe to your point, a fundamental change to your job or to your position can actually happen over time, right? It could be a 6-month period of time. It could be a 3-month period of time. If the end result is, and let's use maybe just the start of the year as an example, if you had, if you were in a position on January 1st, and over the course of the last 3 or 4 months, your position has been slowly eroded and some job responsibilities and functions have been taken away from you over that period of time. Listen, the frequency doesn't matter all that much. What matters is the degree of change between when when you fully had your position and what the difference is now. And ultimately, it has to be a fundamental, or the language that the law uses, it has to be a significant or a substantial change. It should be noted that small changes to your job position, I think everyone would understand, kind of are inherently allowed, right? There has to be some degree of flexibility there in what you're doing or not doing in your job function, right? You can take on an additional task. You can maybe lose a task, and that's not going to be a fundamental change. A fundamental change occurs when really you're doing a position that is not what you signed up for at all. Right? And that can happen. I mean, that can happen even over the course of, again, 6 months or maybe even a year. I think maybe to your point, Andy, and feel free to kind of clarify the question. The concern is if this is now happening over the course of years, that might be a problem, because when we are talking about changes, we are talking about a constructive dismissal. Right? And so a fundamental change would give you the right as an employee to claim constructive dismissal and actually leave the job and obtain a severance package. Constructive dismissal claims need to be addressed in a timely manner. You cannot claim constructive dismissal if the change happened 2 years ago. And so perhaps to your point, Andy, if these changes have occurred over the past 2 or 3 or 4 years incrementally, I agree that might pose a problem for you, because so much time has passed that you might have kind of implicitly accepted those changes. So if you're worried about the timing of when these changes took place, you should be seeking legal advice right away and as quickly as possible. If we're talking a number of months here, that shouldn't be a problem. If we're talking changes that have happened over the course of a few years, listen, that might make it a much more difficult claim for constructive dismissal. Ideally, you want to point to a recent event or a recent trigger point in order to substantiate the constructive dismissal. And so if something has happened to you recently, and again, even if it's over the past few months, now is the time to act, and you really don't have much more time. Hopefully that helps, and at least point you in the right direction. Again, if you have any concerns, or certainly if you want to talk in more detail, you should be speaking with one of our employment lawyers. Again, send us an email, find our information online. Employmentlawyer.ca is the website where you can find their contact information. All right. BC asks, I have a short-term disability claim due to mental illness. Can I travel abroad to send my kids with special needs because nobody will take care of them in order for me to focus on the treatment? The insurance company said they will cut off my pay if I travel abroad. Excellent question, BC, and very, very specific. I think ultimately, the starting point here is we need to look at the terms of your insurance policy. That is the contract between you and the insurance company that governs what you can and what you can't do. Now, clearly, there's going to be some language in the policy that says you cannot travel in order to receive disability insurance. There's actually an analogy here to employment insurance. A lot of times when someone is receiving employment insurance, they're not allowed to travel abroad, or they have to report that they're traveling abroad, and they might not receive employment insurance for that time period. But we'd want BC to take a look at the specific language of the policy, because it might reference, for example, travel for vacation or something like that, which I think is an obvious point, perhaps. You are not in that situation, right? You're traveling for a very specific purpose, which is for your kids. And that might be a little bit of a kind of backdoor way to allow you to continue receiving disability benefits. You should have your doctor's support in that respect. So you might want to speak to your doctor about having him or her write up a note saying this is not travel for vacation. This is travel to basically transport your children somewhere and back. I think you need to speak with one of our disability insurance lawyers, BC, in whatever province you're in, to take a look at the specific terms of the policy with respect to travel and figure out what is allowed and what's not allowed and what you can do to help you out. Certainly, your recovery and your treatment is the priority here. It should be the priority for the insurance company as well, so they should be working with you in that respect as well. All right. Here, Videoland asks, my employer denied my religious exemption to the vaccine, which was signed by my priest. Is this a human rights violation? Do I have a valid claim for damages? Great question, Videoland. Having dealt with lots of these situations, I have seen almost all, if not all, actually, religious exemptions fail in these kinds of situations. If you are in Ontario, Videoland, the reason why I think a lot of these have failed is because the Human Rights Commission in Ontario had, this is now several months ago, released a statement saying that there are effectively no religious exemptions to vaccination policies, and also only two very, very narrow medical exemptions to receiving the COVID-19 vaccine. And so, Videoland, I have to say, I'm not surprised that your religious exemption failed. The Human Rights Tribunal in Ontario has basically already indicated as much in a kind of general guideline. Now, that said, do I necessarily agree with that? No, I don't agree with that. I think these religious exemptions should be upheld. None have been tested yet, at least to my knowledge, and we are up on the law with respect to these kinds of cases. So I haven't seen the Human Rights Tribunal in Ontario address any of these claims. And so one will have to be attempted. You may very well be owed damages as a result, but we have no indication yet from an actual adjudicator within the Human Rights Tribunal as to whether you are or aren't. Certainly there's an argument there. And there would also be an argument to severance, Videoland, if your employment has been terminated or if you've been placed on unpaid leave as a result of a vaccination policy. Guys, we will have to leave it there, unfortunately, for today. I did my best to answer all of your questions. There may be one or two that remain unanswered. And if so, again, you can either contact us off air. You know our contact information. You know where to find us. Alternatively, we will be doing another one of these again tomorrow on Friday, I believe at 1:30 p.m. Eastern Standard Time, if I'm not mistaken. Look out for that, guys. Feel free to ask your questions tomorrow on another live stream. Until then, I wish you all a great rest of the week, a great weekend, and we will catch you here next time for another live Q&A. Have a good afternoon, everybody. Take care.